DowntownEastside.org brings together independent authors to document the stories, events, and challenges shaping Vancouver's downtown Eastside.
Why repeat offenders keep getting bail in British Columbia. In the early hours of December 27, 2023, a man was arrested in Vancouver following an alleged stabbing outside a convenience store. He had been out on bail at the time, with a record of previous offenses. Days later, a similar incident unfolded in Victoria when another individual, also released on bail, was charged with a violent assault. These are not isolated events. Stories of individuals committing serious crimes while awaiting trial on other charges have become increasingly common in British Columbia, fueling public concern about whether the justice system is failing to protect the community. While politicians and law enforcement officials point to repeat offenders as evidence of a broken bail process, legal experts caution against oversimplifying the issue. Bail, they argue, is a constitutional right under Section 11(e) of the Canadian Charter of Rights and Freedoms, designed to prevent the presumption of guilt before a fair trial. Yet, this legal safeguard has left many questioning whether the current system is weighted too heavily toward the rights of the accused at the expense of public safety. The result is a growing tension between judicial independence and public accountability. Judges, often criticized for their decisions to release accused individuals, operate within a legal structure shaped by federal legislation, Supreme Court rulings, and provincial realities. Critics demand tighter restrictions, while defenders of the existing process warn that rushing to limit bail could undermine the core principles of justice. Against this backdrop, British Columbia is now attempting reforms, but whether they will reduce crime without eroding civil liberties remains an open question. How bail actually works in British Columbia. Bail decisions in British Columbia, as in the rest of Canada, are governed by the Criminal Code and shaped by the Canadian Charter of Rights and Freedoms. Under Section 11(e) of the Charter, individuals charged with an offence have the right not to be denied reasonable bail without cause. This constitutional guarantee reflects a fundamental legal principle: individuals are presumed innocent until proven guilty. However, this presumption often clashes with public expectations, especially when accused individuals re-offend while awaiting trial. The process begins with a judicial interim release hearing, commonly referred to as a bail hearing. When a person is charged, the Crown prosecutor must demonstrate why the accused should not be released to the judge or judicial justice. This is known as the ladder principle, which requires the least restrictive conditions to be considered first. Release without conditions is the starting point, escalating only if the prosecution proves that more stringent measures, such as supervision, curfews, or detention, are necessary to ensure the accused attends court, protects public safety, or maintains confidence in the justice system. There are exceptions. The burden shifts to the accused to justify their release in certain cases. This reverse onus applies when individuals are charged with offenses involving firearms, certain drug trafficking crimes, or when they are already on bail for another serious offense. Recent legislative changes through Bill C-48 expanded this reverse onus to include repeat violent offenders and those accused of crimes involving intimate partner violence. Yet, legal analysts caution that such measures, while addressing public concerns, do not guarantee detention. Judges retain discretion, and the presumption of innocence remains embedded in every decision. Judicial discretion or systemic limitation. Judges in British Columbia operate within a legal framework that prioritizes individual rights while granting them discretion in deciding whether an accused person is released or held in custody. This discretion, though essential to ensuring decisions account for the nuances of each case, has increasingly been scrutinized as incidents involving repeat offenders on bail accumulate. Public frustration has at times translated into criticism directed at judges, with accusations that they are overly lenient. However, legal experts caution that viewing the judiciary as the primary cause of the issue risks overlooking the broader constraints under which these decisions are made. Judicial discretion is not unbounded. Judges must apply the Criminal Code's guidelines, adhere to Supreme Court of Canada precedents such as R v. Antic, and respect the Charter's presumption of innocence. The ladder principle, which requires judges to begin with the least restrictive release conditions and only escalate when justified, further narrows their capacity to order detention. While discretion exists, it is exercised within a structure designed to prevent pretrial incarceration from becoming the norm. Critics often overlook that judges are not free to simply prioritize public safety. They must weigh it alongside the accused's rights, regardless of external pressure. Data offers a more nuanced picture. The 2022 report from the Rapid Investigation into Repeat Offending and Random Stranger Violence in British Columbia found that while the majority of those accused of crimes are released on bail, only a small subset, estimated at around 200 individuals, are responsible for a disproportionate number of offenses in urban centers. This group, often grappling with addiction, homelessness, and untreated mental illness, cycles through the system repeatedly. Judges, aware of the broader context, may view detention as unlikely to address the underlying causes of the offending behavior. Critics argue that this perspective can undercut public safety, while others assert that criminal courts cannot remedy social issues that extend beyond the justice system. Repeat offenders and high-profile failures. The growing public unease with British Columbia's bail system is primarily driven by cases involving repeat offenders, individuals charged, released, and then arrested again, sometimes within days. While these cases represent a fraction of all bail decisions, their impact extends well beyond statistical frequency. They shape public perception, influence political discourse, and raise questions about whether existing safeguards are sufficient to protect the public. A small group of individuals, often labeled as prolific offenders, has been shown to account for an outsized portion of criminal activity in British Columbia's urban centers. Police and court data indicate that some members of this group have been involved in dozens, and occasionally over 100, separate incidents within a single year. Many were charged with property crimes or nonviolent offenses, but others had histories of assault, weapons possession, or threats against the public. In one case cited in the investigation, an individual was arrested 92 times over a year. Critics argue that such patterns demonstrate that bail decisions are enabling a cycle of release and reoffending. However, Crown prosecutors and defense lawyers suggest the issue is more complex. Many repeat offenders experience acute poverty, untreated mental health conditions, and substance dependence. Defense counsel often argues that detaining such individuals pre-trial may interrupt their access to housing or health services, pushing them further into instability upon release. At the same time, Crown prosecutors face challenges proving that detention is necessary when the offenses, viewed individually, may appear minor, such as shoplifting or mischief, despite the cumulative risk posed by the offender's repeated actions. This raises a critical tension. Should bail decisions be based on the severity of a single charge or the broader pattern of behavior exhibited by the accused? Federal legislation and provincial realities. Bail laws in British Columbia are not crafted within the province. They fall under the federal jurisdiction of the Criminal Code of Canada, meaning that changes to the bail framework require action from Parliament. This legal structure can create tension between provincial governments responsible for administering justice and Ottawa, which sets the rules judges must follow. When repeat violent offenses occur, provinces often bear the brunt of public criticism, but their power to enact meaningful reforms is limited. Recent efforts to address public concerns culminated in Bill C-48, which received royal assent in 2023. The legislation expanded reverse onus provisions, placing the burden on accused individuals to demonstrate why they should be released if charged with specific violent offenses while already on bail. It also targeted those accused of intimate partner violence and weapon-related crimes. The changes were intended to reassure the public and close gaps in cases involving high-risk offenders. However, legal scholars and defense counsel have questioned whether such measures meaningfully address public safety. Critics argue that placing the burden on the accused does not guarantee detention. Judicial discretion remains central, and reverse onus is not a presumption of guilt. Judges must still weigh each case individually, applying the principles outlined in the Charter and past Supreme Court decisions. Provincial officials in British Columbia have expressed support for the federal reforms but caution that legislation alone will not solve the problem. The Safer Communities Action Plan reinstated the Prolific Offender Management Program, focusing on individuals responsible for a disproportionate number of crimes. While these measures signal a desire for action, some legal professionals argue that their effectiveness will depend on broader investments in mental health, addiction treatment, and housing. Without these supports, they contend, legislative changes risk creating a revolving door where offenders are detained briefly, only to return to the same circumstances upon release. Court backlogs and overcrowded prisons. Bail decisions in British Columbia are not made in isolation from the justice system's broader pressures. Court delays and capacity issues within correctional facilities have become increasingly influential factors, shaping the choices available to judges and Crown prosecutors. While these structural limitations are rarely acknowledged in public debates about bail, they play a critical role in determining who is held in custody and who is released. The province's court system has long struggled with delays. The BC Prosecution Service, responsible for presenting bail applications, operates under significant strain. A 2023 review of provincial court performance highlighted that some trials are being scheduled more than 18 months after charges are laid, pushing the limits of the Supreme Court of Canada's Jordan decision, which mandates that cases in provincial court must generally be completed within that timeframe. When judges consider bail, the reality is that detaining an accused person could mean holding them for months, sometimes longer, before their trial concludes. This raises practical concerns about fairness, particularly when the individual may ultimately be acquitted or sentenced to a penalty shorter than the time spent in pretrial custody. Correctional facilities face parallel challenges. Provincial jails, such as those in Surrey and Prince George, have experienced capacity pressures, exacerbated by the growing number of individuals detained pretrial. In 2022, approximately two-thirds of the province's incarcerated population were individuals awaiting trial, not serving sentences. Some defense lawyers argue that judges may hesitate to order pretrial detention for nonviolent offenders, knowing they will enter an overburdened system where conditions are often harsh. Conversely, police and victim advocates contend that these pressures should not outweigh public safety considerations, particularly when repeat offenders are involved. These tensions expose a deeper reality. While legislative changes and judicial discretion are often blamed for bail outcomes, the practical limits of British Columbia's courts and corrections system exert a quieter but equally decisive influence. Safer Communities Action Plan. In response to growing concern over repeat offending and public safety, the British Columbia government introduced the Safer Communities Action Plan in 2022. The centerpiece was the reinstatement of the Prolific Offender Management Program, which had previously run from 2008 to 2012. The program brings together police, prosecutors, and support services to monitor and manage individuals responsible for frequent criminal activity. Early feedback from law enforcement suggests improved coordination, though legal advocates warn that without parallel investment in mental health and addiction services, the program may simply accelerate the cycle of arrest and release. The plan also expanded intervention teams to connect individuals to support before criminal behavior escalates. Police have credited the teams with preventing incidents, but their impact has been uneven. Municipal representatives outside Metro Vancouver have raised concerns that resources remain concentrated in urban centers, leaving rural communities to manage repeat offenders without comparable support. These disparities reflect a broader challenge in British Columbia's justice response. Targeted interventions are often deployed where political attention is highest, while smaller regions face familiar patterns with fewer tools. Critics of the plan question whether it can achieve lasting results without addressing the underlying pressures on courts and correctional facilities. Some prosecutors argue that escalating pretrial detention is necessary for individuals repeatedly breaching conditions, while defense lawyers caution that incarceration without rehabilitation merely delays reoffending. The plan's long-term success may ultimately rest on whether it bridges the gap between enforcement and social support, an outcome that remains uncertain as public expectations continue to mount. Protecting public safety while upholding rights. The tension between individual rights and community safety underpins every debate about bail in British Columbia. While recent reforms have sought to address public concerns, their success hinges on whether they can reduce repeat offending without undermining the presumption of innocence, a cornerstone of Canada's legal system. This balance is not easily achieved. Legal scholars warn that toughening bail restrictions risks disproportionately impacting marginalized groups, particularly those experiencing homelessness, substance dependence, or mental illness. Detaining individuals without addressing the conditions that brought them before the courts may prevent immediate harm but often delays reoffending rather than preventing it. Law enforcement and victims' advocates view the matter differently. For them, public safety is not an abstract legal principle but a daily concern. They argue that a system that routinely releases individuals with lengthy records and histories of non-compliance erodes confidence in the courts. Cases involving violent assaults by individuals already on bail leave communities questioning whether legal safeguards have been prioritized over preventing harm. This perspective has driven calls for stricter detention criteria, with police representatives urging further adjustments to reverse onus provisions, particularly for those repeatedly breaching conditions. Others point to an underlying flaw in the entire debate: the expectation that bail reform alone can resolve what is, in many instances, a social crisis playing out in the justice system. Individuals arrested repeatedly for property crimes or minor assaults often return to the same conditions upon release: housing instability, untreated addiction, and a lack of mental health support. Without parallel investments in these areas, even the strictest bail laws risk functioning as a short-term barrier rather than a solution. While courts determine who is released, it is governments that decide whether the conditions enabling repeat offenses will be addressed beyond the courtroom. Rethinking bail beyond detention or release. The debate over bail in British Columbia is often reduced to a clash between judicial leniency and public safety. This framing, while politically effective, overlooks the system's deeper complexity. Bail decisions are not made in a vacuum but at the intersection of legal principle, systemic limitations, and social failure. Judges operate under federal law, bound by the presumption of innocence, while provincial courts and jails struggle with capacity issues that quietly shape outcomes. The public's demand for protection is reasonable, but the expectation that the bail system alone can deliver it may not be. Recent legislative adjustments, including Bill C-48's expansion of reverse onus provisions, reflect growing pressure to contain repeat offending. However, whether these measures will meaningfully reduce crime remains uncertain. Police statistics in some jurisdictions show that a small group of offenders drives a disproportionate number of incidents. Detaining these individuals might reduce short-term harm, but it does little to prevent others from following the same path. Long-term safety is unlikely to be achieved by simply tightening bail conditions if the underlying issues, addiction, housing precarity, and mental illness, remain unresolved. There is an alternative perspective that receives less attention. Bail reform is often discussed as a contest between release and detention, but what if the flaw lies in the binary choice itself? Jurisdictions in Europe have experimented with bail supervision programs that place accused individuals under intensive monitoring, with daily check-ins and access to support services, reducing both reoffending and unnecessary pretrial incarceration. British Columbia's reliance on bail conditions, curfews, no-go zones, abstinence clauses, frequently assumes that compliance is realistic without addressing the conditions driving breaches. A system that supervises rather than merely restricts could better reflect the reality of those cycling through the courts.